Welcome to Mastering Legal English Podcast. Today's episode is Contract Drafting, Mastering the Language of the Deal. I'm Steve Kahaner, a U.S. attorney licensed in New York and Connecticut, and currently the owner and operator of a translation company focusing on the translation of corporate and legal documentation.
Great, and I'm Charlie Shan, and if it's your first time listening, I'm an English coach for lawyers and an international entertainment consultant. And today we have a very special guest making his first appearance. Steve, who do we have on today?
Today, I'm very pleased to present Carlos de Cardenas Smith. He's a partner at Uria Menendez, one of Spain's biggest and some would argue most prestigious law firm. He's been the head of corporate practice for more than 10 years. And he was in charge of Uria's New York office back in the 90s, where we first met. Carlos. So
Hi, Steve and Charlie. Thank you for having me on your show. It's a pleasure. Yes, we met in New York like 30 years ago, I think, or maybe 28 years ago now.
Long time.
That's right. Yeah, I was first working at the New York law firm as an international associate, and then heading our New York office 97 to 2000. And that's where we met, I think, several times in the train, actually, didn't we?
I think so. And also, I think, were you a member of the Inter-American Affairs Committee of the New York City Bar?
I was.
I chaired that for a few years, and we had some mutual friends from that era.
Right. Yeah. And so I did have to deal quite a lot with drafting in English. As you can imagine, I worked for many U.S., particularly New York, but not just New York law firms, and did receive really, looked to me at that time, very complex, long documents, contracts, offering circulars, disclosures, all sorts of documents that I would have to review pretty quickly and many times draft too. So whenever there was a Spanish party and an American lender or whatever, I did have to draft quite a lot. So that's how I really learned, by practicing. That's it.
And that's why I thought it would be perfect for you to join us today, because we're going to be talking about contract drafting, form, style, the standard contracts intended for domestic use in Spain will look very different than an international contract with parties from different countries, often following either the American or the UK style of contract drafting. So I thought it'd be great for young Spanish lawyers who are entering the field to get to know a bit about. Obviously, in a 1 hour segment, we can't give an in-depth course, but we can talk about the differences and what they need to think about when they're drafting contracts in English. Does that sound like a interesting topic for discussion for our listeners?
Yeah.
I certainly hope so.
I think one of the main things to think about are stylistic differences. Why do these international or US or UK based kind of contracts seem to look so different than a contract that would be drafted, in Spain for local purposes? Do you want to talk a little bit about the systems and how they have an effect on the form of the contracts?
Yeah, you mean common law versus civil law systems? That's what you mean?
Yes, yes, absolutely.
Yeah. Okay. Well, I think it's fair to say that in your way of drafting, it's not that different between an English lawyer and an American lawyer. At least, maybe for you it is, but for us it's quite similar. You try to spell out absolutely everything. So you create your own sort of closed system in the contract, and everything's there. No, we rely on our civil code, which is, it's been reformed, but it's from 1885, and that's the case, I think, of France, Italy, Germany, I mean, most continental Europe, I would say, will not need to spell out and fill every gap, every inconsistency, every ambiguity in the contract, but you can rely to some extent on the civil code. You don't need, for instance, to state that the party will act in good faith or reasonably, because they are expected to act in good faith. They're required to act in good faith, in fact, and act reasonably. So that's just a very simple example, but you could have many other examples of things you don't need to spell out. Now, that doesn't mean you don't, in Spanish law governed documents in English, we tend to follow more and more the, Anglo-Saxon way of doing things. So they tend to be longer and longer. When I first started practicing a Spanish syndicated loan here at the firm was around 25 pages. And I can tell it was a beautiful document. It was beautifully drafted. Now we use LMA form, and it can easily be 150 to 200 pages long. I'm not, I guess that's inevitable, and it's a product of what clients, banks, investment banks, private equity houses, etc., expect to have, and two, it's just simpler to cut and paste than it used to be back then, where you had to actually type the contracts. That was only at the very beginning of my career, but I saw that happening. Actually, it's not like I was told that it happened. I saw it happen. So you had to be careful on what you wanted to write down, because it was burdensome.
Yes, I do remember that transition quite vividly. And I had to become a very fast typist myself, growing up as a young lawyer, without a secretary. And either you wait several days for the pool to get you back your document that you've dictated, or you just learn to become a very fast typist, which I chose the latter. And I think one of the other reasons why the Anglo-Saxon style contracts are much longer, at least in the United States, is because the parties basically consider the contract to be the law between the parties for that particular transaction. So it is the law, and you try and cover as many areas as possible, because if you don't, it's so very difficult to determine what law actually applies in default of you actually handling that provision. And I think that and correct me if I'm wrong, in most civil law countries, but the parties do pretty much understand what the law is that will apply to the contract, looking at either the civil code or the commercial code. That's going to give you the law. Whereas in the US, finding that law tends to be a little bit less straightforward. And the courts are used to the parties saying, this is what we want to apply to this transaction in the United States.
Yes. No, and our contracts look more and more like yours. That's because also in Spain and in continental Europe, the law is whatever the parties agree in the contract. It's the same. It's just that we have some rules of interpretation if it's not clear what the parties, if there's a gap, if there's inconsistency, if there's something vague, then you have some rules of interpretation that apply. No, I don't know if you have that. We do have that.
Sure.
It doesn't mean that the outcome of the interpretation is always going to be the same. Depends who you ask, obviously, but you do have some rules.
All right.
With documents getting longer than they used to be, part of it's got to be new lawyers just using templates and boilerplates and AI. Do you think that's also an aspect? It's the kind of the new lawyers just using these templates.
Yes, that's another big difference from when I started practicing. We had few precedents and very few templates, and now you can, with I think in any firm now you can find almost templates for anything, and so it's the work is more efficient now. Sometimes I'm concerned that people use templates without really thinking and going through the different provisions carefully and thinking whether they make sense or not in the particular deal. And that's something you have to fight against, because you can't just assume that because it's in templates it's right, or in a present where the circumstances could have been completely different, or maybe the firm was acting for the creditor, not for the debtor, or the other way around, or the purchaser instead of the seller. So you have to use some judgment. You can't just copy and paste and say, well, I just use the present. That's not the way things should work.
It reminds me of a funny anecdote from our days on the Inter-American Affairs Committee. I don't think you were there, Carlos, but we had a couple of Chilean lawyers who were humbly suggesting that maybe some of these boilerplate clauses weren't the best to be using for, under Chilean law that would be, analyzed by a Chilean judge in the event of a dispute. And one of the lawyers for one of the big financial institutions turned around and said to them, "Are you crazy? You think you're going to slow down our deal flow by negotiating these provisions or taking them out? Forget it." So it's it may have been a little bit jingoistic, as we say, but there is this argument for using the same templates just because you don't have time to negotiate every provision if you want to keep that deal flow going. So
that's right.
Whether it's right or wrong, I'll leave that to.
It's the reality. It's just the reality. But I think you have to find some time to think critically, and also, I think it's good to, before sending it any document, reading it several times. I'm sure you, as a lawyer, both of you as lawyers, have noticed that if you write something and then just leave it for a few hours and read it again in the afternoon or next day, lots of things will change. And that's one of the things I normally recommend our associates is I call it the fridge rule. You put it in the fridge, you wait till it cools down, and then when you come back next day or in the afternoon, you read it again, and I'm sure you will find lots of things that could be, can be improved, and you can do that. So if you can do that several times, I don't think the client will let you do that, because they will be rushing you to send the document. But ideally, if you can do that, you will have much better work product after several revisions of the document. We all experience that.
It's very good advice. Although I suspect that what many are now doing is throwing it over to an AI tool and having the AI tool give them suggestions and comments.
Yeah, and I do it myself with some letters that I find delicate or difficult to, I do run it through the AI, as you say, and I do look at the suggestions, and sometimes I accept them, sometimes I don't. Doesn't work beautifully, I have to say. That it's not seamless, it's not perfect. Sometimes it's not understanding the tone that you want to give to a certain. So you have to, again, it's like the templates. You have to use them carefully.
Yeah, considering a lot of people are using templates and AI anyway, it's still important to talk about drafting clauses. So why don't we begin with the basics of drafting a clause? Steve, do you have a golden rule when it comes to this?
I guess if your sentence could double as a riddle, you've done it wrong. That's one way to look at it.
Yeah, and the idea is if it's going to be clear, it doesn't have to be boring, but would you recommend, for example, a confidentiality clause that would read like a Shakespearean sonnet?
Like Shakespeare, as in, "Thou shalt not blabbeth trade secrets"? I don't think so. I think, you want to keep things simple: subject, verb, object. The contractor shall deliver the goods by May 31st. I think is the more appropriate way. Be boring. Lawyers aren't supposed to be artists. So, you want to make it clear and not subject to interpretation as much as you can.
I really like subject, verb, object, because a lot of times people do, especially coming from Spanish, they put the word order incorrectly. I'd also say it's great to avoid double negatives really archaic words like heretofore and semicolons when they don't apply.
Yeah, there are lots of tricks I think you can, I mean, lots of tips that you can give a Spanish lawyer, because obviously our drafting in English is not as good as yours. But I think what I find reviewing English in documents all the time are, I would say there are some common mistakes that, or some tips that I could give a Spanish lawyer, because I see time and time again that, always find the same problems is using the passive voice. I really hate that. So use the active voice. You don't need to say it is stated in Article 3 of the Civil Code. You say Article 3 of the Civil Code states. So that's one that I particularly hate. The other one is using subordinated sentences and not being able to break down a sentence, a big paragraph in several sentences. Being concise. I will delete every time I see the word proceed to deliver. No, deliver. Why? I mean, or please find below. Why do you say please find below? Period. You don't say please find below. And so I normally the corrections I will make to a lawyer are not adding text, but deleting text and making simpler, shorter, phrases or sentences or whatever, or clauses. Then ambiguity also. That's I think that's something some Spanish lawyers tend to like, to be ambiguous. They think it may help them in some cases. I don't think that's the case. Using consistently the same terms. You will find many times in a Spanish contract, the company, whatever a cell, whatever, but without a cell, or the first party, and never the same term, or buyer, purchaser, acquirer. Well, say buyer or purchaser or acquirer. I don't use the three terms, no. So that's the sort of thing you will find.
I think that's
you've seen
bit
that many times. You've seen that many times, Steve.
Yeah, I do. I've seen it way too many times, but I think that is due to this emphasis in school and in learning how to write, this idea of elegant variation, that in Spanish, when you keep repeating a word, it's actually frowned upon. It's
You're right.
encouraged to look for an elegant variant of that word. And
You're right.
unfortunately, this drives U.S. lawyers crazy, is that bleeds into the legal drafting, where you really don't want elegant variation because you don't want ambiguity, as you just said. You want things to be clear. And if you start referring to different parties and different concepts with different names, you could really run into trouble if you go to litigation.
Yeah, I think you are absolutely right. It has to do with the way you're taught, how you're taught to write in school, and it's okay in a non-legal context. But as a lawyer, you have to be first and foremost precise. You cannot take risk. So if you can be elegant, that's even better. But the first you have to be precise and clear. And so that doesn't help sometimes. Another thing is that you find probably lots of capitalization, capital letters that are not required, because in Spain it's true that many people, and it's incorrect, by the way, even in Spanish, to use so many capital letters. So it's either a proper noun or there's some other exceptions, but other than that, or a defined term, you should not be using a capital letter. Also, Spanish lawyers, particularly people in litigation, I have to say, love using Latin phrases. So any American or English lawyer, Canadian lawyer like Charlie will understand what pari passu means, but there are hundreds, literally, of Latin expressions that only lawyers in certain continental countries here in Europe will understand what they mean. So why are you using those terms? I mean, because you think
not only that, but some Latin terms have different meanings in the different systems. So you have to be. I'd have to go back to my books to pick out the ones, but they actually do have different meanings and are treated differently depending on which system you're in.
And then you have the last one I would mention is the false friends. I think you had already a podcast about this, but absolutely anything. Like repudiation of contracts. What's that? There's no such thing in Spain. You are obliged, you're not obliged. There's no repudiation of a contract. You're in breach or you're complying. It's not like it's irrelevant if you repudiate a contract. Like if I say, I repudiate the Spanish tax code, nobody's going to care. It's going to apply to me anyway. It's the same. So there are lots of things like that. People saying that the Spanish company is in good standing doesn't mean anything. The Spanish company is duly incorporated or organized. It's not in good standing. Good standing has a precise meaning in the US, means nothing here. So you should avoid these things. Or sometimes terms like security. What you consider security is not exactly what a definition of security in a New York law governed or English law governed loan agreement is very broad, much broader than what security is under Spanish law. So you can't just take for granted, I'll just translate it, I'll put it in DeepL, and it will be fine. It will not be fine.
Yeah, and this is the difference, that especially in financing agreements that we come across is, the proper translations of garantía real, garantía personal, aval. These all have specific meanings, and they do have more or less functional equivalent. It'll never be exactly the same, but
Right.
more or less functional equivalents. Garantía in this concept, in this surrounding, is not a guarantee. It's what we refer to as security, whereas garantía real is typically what we would refer to as a security interest.
That's right.
And so these are things that concepts that the Spanish lawyer needs to get familiar with, and finding those functional equivalents in English when they're drafting in English.
That's right. That's right. And if you have a doubt, what I recommend is putting the Spanish term in parentheses, and so you say security, garantía real. So I think that the risk of misunderstanding is lower then.
So Charlie, what do you do? If you've written your clause, now you're going to go back and you're edit it. What do you do when you're drafting?
Yeah, for editing, I will say that false friends are extremely important to watch out for. But also reading it out loud is really important. So if you sound like a confused robot, like a lot of AI generated YouTube right now, you can just tell that needs fixing. And also cutting about 20% on the second draft. I'm a big fan of the fridge technique because I've been shocked if I take a walk and I come back, the things that pop out that I didn't see before. So the idea is legal writing is like luggage. The less you pack, the better the trip.
Yeah. And there's another fact. There's another rule recommendation I try to I tell my associates to follow if they can. They should follow because I think it's important. Contracts tend to get more and more complex. I was reading a New York law government document just a few minutes ago, and it was amazingly complex. And if there's a dispute, that's going to the New York courts. Okay, the Second Circuit of I don't know what thing. I mean, I never remember. I never understood your system in that respect. So it will end up in the desk of a New York judge, who's very sophisticated individual, and that's great. And we have really smart judges, but they are not specialized, and they're not used to seeing contracts that are 200 pages long. That if they are hard for me to understand, I bet it's going to be even harder for them to understand because they will need to also be translated to Spanish from the English. And it's going to be a nightmare. So that's what I call the rule of the Plaza de Castilla. The rule of the Plaza de Castilla is the place where many of the civil courts in Madrid are located. So I say, is this going to be understood by a judge of the Plaza de Castilla? Yes or no? If it doesn't meet that test, you should redraft and make it simpler, because why do you want to have a contract that in the event of a dispute, nobody's going to understand? Yeah.
Very good advice. Yeah. Well, I agree wholeheartedly. You just don't want to be too minimalist. You don't want to
No,
have a contract
no,
that just says, either party may terminate, full stop. Uh,
no.
That's both. I almost I was given something to review once like that, and I added a couple sentences just to make it look a little bit better. But it is a lawsuit waiting to happen.
and so if you define how, when, what happens next, be concise, I think you're going to be in a good place. And there's one thing that's one of these bugaboos. That's a great word for non-English lawyers to learn. Little bugaboo means a little thing that can come back and bite you. Is this whole concept of plain English? I don't know how much at your firm, the plain English rules have permeated uh, uh, thinking, but I've always tried to tell the translators at the very least that plain English doesn't apply. When you're translating, you translate exactly at the same register
Yeah,
as the source document. And because, you know, we're talking about sophisticated parties with sophisticated lawyers, I don't think you need to worry too much about plain English rules. You do need to worry more about what is expected, what people are used to, what is market for drafting these clauses. It's like writing computer code. You don't expect the everyday consumer to understand computer code. The
hmm.
same way that sophisticated lawyers, when they're drafting, aren't drafting for the general public. They're
Yeah,
drafting for each other, and they've been doing this a long time. They're sophisticated parties. They don't worry about having to reduce, to subject, object, pronoun simplicity like you do when you're drafting for the public. So
yeah.
it's just one thing I just emphasize. Don't worry too much about plain English rules at this level when you're drafting for an international transaction where the parties are sophisticated. I don't know. What do you think about that, Carlos?
No, I agree. I agree. I mean, it has to be first and foremost has to be precise, and it's important, obviously, that what I said before. I think if it will end up in a Spanish court, I think you should pass that test. If you think the Spanish court is not going to understand because it's so extremely complex, you should think a bit about it. Okay. For instance, you you may have your credit agreement subject to New York law, but your Spanish pledge agreement will need to be subject to Spanish law. And that's going to end up in a Spanish court. So a pledge is not a big deal. I mean, it's a 25-page document. It's not a huge or very complex document. But sometimes people tend to complicate things unnecessarily. So, always try to, put yourself in the situation of the judge that receives that in his or her desk, and comprehensible or not. Of course, the judge has a robust training in law, and you can be as technical as you want, but it must be comprehensible.
Yeah, I mean, yeah, if you have a permitted acquisitions definition that goes on for 10 paragraphs
Or
uh,
10 pages,
or
or
10
10 pages,
pages.
or 10 pages, with hundreds of defined terms that go to another defined term, that go to another defined term. I mean, that's the sort of situation I'm concerned about.
Right, right.
I tell lawyers that when they want to say furthermore and however, it's in like document drafting. So this is where they get to really say it. But when they're speaking normally, they've got to tone it down. But is it time now to do a bit of a show and tell and move on to the format?
Sure,
Yeah.
sure.
Okay, so I'll load it up. What's that first? What are we looking at here, Steve? If you're watching on video.
Yes, I can see it. That is a cover sheet, and they are used. It's a single page at the front of the contract. You'll see here. I don't know if you can read that. It says execution version. Sometimes they'll have the version control on that first page, but this is the document that's actually signed by the parties. Carlos, when would you use a cover page?
When
Would
the
you
contract
slap it on
is
a 5-page contract?
no, when the contract is fairly long. I mean, these places I was mentioning before, they don't even have a cover page or an index many times. So we're talking about contracts that are, I don't know, 30 pages long or more, maybe 40 pages. Then it may make sense. And they will look very much like that one, maybe a bit more detailed in Spain, but essentially the same.
What about that title? What do you think? How specific should the title be? Could you just put agreement there?
Yeah, you could put agreement,
Could you
of course,
put,
but I think in Spain
in
you will
Spain
find.
it's typically contrato de compraventa de participaciones sociales, and so you'll see people putting agreement for the purchase and sale of equity securities. Would that be appropriate?
I mean, in Spanish doesn't sound that bad. I mean, the translation is very difficult. But I think we tend to be more detailed. We would say contrato de compraventa de acciones de la sociedad. You would put the name entre A, B, and C as sellers, and H as purchaser. Dated. So it will be fairly detailed.
But if they're drafting an international contract and they need to put a title on this document, what do you think? I mean, is agreement enough? Is stock purchase agreement enough?
I would say stock purchase agreement.
I agree.
Or share purchase. I would normally use here share purchase agreement, but I mean, I don't know what's the right.
Yeah, stock is more American. Share is more
American.
continental, UK, whatever they call European English these days. So you showed us quickly, Charlie, the next page. Ooh, the table of contents. What do you think about a table of contents for a 6-page contract? Yes? No?
Well, I mean, it'll obviously help you read a 6-page contract.
No, I don't think it makes sense. Again, it's like the cover. You will have an index when it's, I don't know, more than 30 pages, at least more than 30 pages.
And for the audience, index and table of contents mean the same thing.
In Spain, we say index, but it's table of contents, I guess. Index of the defined terms is a different thing.
They're both types of indexes, but yes, I've seen it both ways.
Yeah.
So again, index of defined terms. This can go on for pages as well. You'll see, where is this term used in the contract, and it'll refer you to all the places.
Yeah, we use it quite a lot, but not always. I think what you will see more and more is section 101, which is defined terms, and you will have there the list in alphabetical order. So with that, I mean, and any word system will locate any word you want. So I think you may do that, but it's not going to be used really, because I have to find the word confidential information, which I'm seeing there in the screen. I'm not going to use that. I'm not going to even trust it. I'm going to use my processor, and I'm going to look for confidential information. It's going to take me through every paragraph where it's used, right? So
it's true. It's true. You can't trust that index because
I would not trust anything.
That they don't pick up all of the occurrences.
Lawyers don't trust anything, so I'm not going to trust it. I'm not going to trust it. I wouldn't even bother reading that index, frankly.
But you probably would have it for a big contract, wouldn't you?
Yeah. We do have them. Yes.
That's very funny. Okay. Would you then trust the opening paragraph? I assume.
This is what I call an introductory clause. Yeah.
Ours are much more detailed, as you know, Steve.
Well, yeah, this is the big thing that the Anglo-Saxon system tends to be a pretty simple statement of, the name, the date, the parties. That's pretty much it. And I don't know. In Spain, I think it's quite different. Your introductory clauses. No.
Yeah, maybe it's worth stopping here for a minute, which is, we do give details of the parties. We don't just say company X, a Delaware corporation. We say the name of the company, its corporate address, its tax identification number, even its registration details in the commercial registry. And we do the same with each person representing that company. Because it's quite important in Spain, and in that our system is very different from yours. You are authorized to represent a company if you are either the holder of a power of attorney issued by the management body of that company. That can be a board of directors, but it can be a sole director also who has granted the power of attorney to you. And any management body can grant a power of attorney to anyone. I can grant, if I were a company, I could grant it to you if you have anything to do with my company, or to a lawyer, or to anyone. So you either have that, or you are the management company who's signing. I mean, if I'm the sole director and I'm signing the contract, as sole director, I'm authorized to represent the company. So I just have to show that I was appointed sole director and that my position is still valid, has not expired. And if it's a board, since you don't have all the board signing the contract, the board acts through what we call the consejero delegado, which is similar to your CEO. So in Spain, you have to check very carefully if the person signing the contract is indeed one of the two. If it's not, you don't have a contract. Basically, you don't have, the other party is not bound. Even if that person has the appearance of being representing the company, with some exceptions, but you don't want to have the burden of proof. So to be prudent, you should either check that that person has either the power of attorney or is the management body itself.
Absolutely. In Spain, I think it's important for young lawyers that are drafting contracts to understand that that is not typically a big issue for UK or US lawyers or Canadian lawyers. That you do have representational capacity. If you're the president, by its very nature of the position, you can sign on behalf of the company. You don't need a power of attorney. If your name is at the end of that document as the signatory, that's enough, and a court will enforce it. You don't need to have a separate power of attorney. We typically don't have the concept of a consejero delegado in the sense that a consejero delegado really means the delegated board member. You're a board member who's been delegated the entire powers of the board.
That's right.
And the Anglo-Saxon system, this concept of the board and the officers is much more separated. You have a president or a CEO who's typically, it's not always the case, but typically is not necessarily a member of the board. They're an officer and they have full representational powers of the company. And so when you're a Spanish lawyer, you're drafting, I think it's just good to keep in mind that, the Yankees, the Americans, are not going to appreciate a very detailed, complex introductory clause. They're used to very short, concise clauses or paragraphs rather that has the name of the agreement, that short name, stock purchase agreement, the date, you may define agreement, the short name in that first introductory clause. And then you name the parties, the kind of company they are, and you define them as buyer and seller, and that's it.
Right.
3 or 4 lines.
That's right. And you can do that. It's just that in the back, you should be checking that the person signing is indeed empowered to do that. Whether you want to spell it out in the contract or not, that's your option. But you should be checking that. Just because the person signing is the CFO doesn't mean that he or she has any authority to bind the company. Not at all.
What about dates, Charlie? Do you typically draft a contract and put 1/2/2025? Is that good enough?
This is relatively controversial. Depending where you are in the world, like Canada, US, or Spain, there are very strong opinions on whether the date or the month comes first. And if you're interested in late payments, you can play this Russian roulette game. Obviously, the best thing is to write it all the way out, because if you go 1/1/2030, that one's safe. But in Spain, the date comes first, but not so much in the US. So that's it took me like months to get used to it when I moved to Spain.
Carlos, do you ever refer to June 5th, 2025. So
I
I
would
see a lot
say,
of Spaniards using June 5th, and for an American lawyer, that's improper. You
no,
would
I
not
wouldn't do
use,
that. I mean, I would say June 5, comma,
right.
2025.
So
But
that's, I see that a lot with the Spaniards drafting in English, as they put the 5th in there
yeah,
with a DH, and you should just be aware that no, we just use the numeral, the Arabic number, and that's it.
that's maybe because it sounds like the 4th of July.
Yes, yes. And you can say the 4th day of March if you want to be very formal. You don't see it a lot.
I think it's very formal. It sounds to me very formal.
Carlos, what if one of the parties is acting? You see this a lot in the financing agreements, where one party is acting for itself,
Yeah.
but also, let's just say, on behalf of other parties. You need to distinguish it. Would you include in the introductory clause kind of a description there and a definition of them when they're acting as something else?
Absolutely, yes. That's very, very common, as you know, with agents, security agents, collateral agents, trustees. That sort of situations where you, again, if you have, for instance, security subject to Spanish law, you will have to, and I didn't mention this yet, another particularity about Spanish law is you will need to go to the notary for certain types of contracts. A security interest cannot, I mean, there are exceptions to this, but not worth mentioning. You need to go to the notary, notarize the security document, and sometimes even register it in the real estate registry. Mortgages need to be registered. Otherwise, they don't exist. Share purchase agreements. You transfer the shares of a Spanish company, you need to have the agreement notarized. Or there are other situations for these type of contracts. When you have a security agent, for instance, you will have to describe in the document by virtue of which authority that agent is acting on behalf of all the lenders or creditors. It's not just because the loan agreement or the inter-creditor agreement says that the collateral agent may do that. But you will have to go to the notary with a power of attorney issued by the lenders in favor of the agent, and you need to have that notarized in the jurisdiction where the lender is located, and then apostilled. Okay, I can go through that process if you want in more detail, but it's quite formal. If you want to have the certainty that the collateral agent is in fact representing all the lenders, in an event of enforcement or in event of insolvency, you're not going to have problems, because that's what we call the acid test. That's when you are going to know if it's really working or not.
But in the introductory clause, would it be sufficient, as we do in English, to say Acme Bank, comma, NA, comma, as collateral agent for the secured parties, parentheses, in that capacity, the quote, collateral agent? That's how we would do it. Is that
In the
good
contract,
enough?
you can leave it like that, but then you have to go for the pledge that I was talking about. That's your loan agreement, okay? So now you have the pledge. In the pledge agreement, under Spanish, you have to be more precise, and the notarial deed will describe with all detail where that authority comes from, okay? Because the power of attorney that's going to be executed will prepare for the lenders, will say that we are authorized to sign on behalf of that lender a credit agreement in the amount of $180 million, a share pledge agreement, and sort of listing more or less at least what the transaction is about. And with that document, the U.S. lender will go to a U.S. notary that will have to attach to the power a notarial certificate saying that the person that signed the power of attorney in New York in my favor to sign here in Madrid is indeed an officer of the company and can represent and bind the company, okay? And with that, and after that, you'll need to have an apostille on top of that, because the Spanish notary is going to say, okay, so I have this gentleman saying that he's a notary public of New York. How do I know? Because there's this convention saying, if you have the apostille, you can be certain that that comes from a real notary in the
Hague
jurisdiction.
Convention. But
So
I think
it's very burdensome, it's very formalistic, but there's nothing I can do about it. I know you have to go through this. I've explained this hundreds of times to English and more particularly to New York lawyers. And I mean, in very big international firms, they already know it's the way it is. And in many other continental countries, it's like that. But sometimes they're like, oh my God, what's this? No, I understand. Yeah. It's very big.
They consider it a PITA. A PITA. You'll see that notation sometimes. I don't know if we can say racy words on this podcast. A PITA is a pain in the ass.
It's in a pain in the ass.
So the U.S. lawyers consider it a considerable PITA, and why do we have to do this? Why do we have to go through this? But I think it's very important for young Spanish lawyers to know, if they don't already, that a U.S. notary has nothing to do with a Spanish civil law notary public.
We know that.
Do all of the lawyers know that pretty well at this point?
Yeah, at this point they do, because when I practice in New York, a notary public I would say, in Spanish you understand the expression, firmará la muerte de Manolete. He will certify that he killed the bullfighter. Okay, Manolete. No, they would sign anything really, but it's changed a lot. So nowadays we have lots of problems with notaries in the US certifying what the notary in Spain needs to see. So what they end up doing is, yes, before me appears Steve Kahaner, legal aids, whose signature appears below. He states that he's authorized, and he gives me a copy of the Article of Association and the board resolution, and with sort of composing a certificate with all the deliverables that you hand out to the notary. And with that, again, it's, I don't know why, but Spanish notaries like to see lots of stamps, seals, and papers. So with all that, you go, you have it, and then you go to the apostille, and then you have a power of attorney. But there has to be somewhere where you can conclude that you, Steve, are representing the company and you are authorized under New York law to do so, or Delaware.
But the notary, a U.S. notary, can't do that.
But they can say that the Articles of Association state this or that, or the Delaware law. I don't know. We have several ways. Some notaries are flexible. Some notaries are very inflexible. So we have several sort of plan A, plan B, plan C. So that's
right. But they're skirting what we call the UPL, which is the unauthorized practice of law, if they're opining that somebody is indeed under the law entitled to do a particular act. So
maybe they don't even opine, because what they're just saying is that they have seen that the company is incorporated under the laws of Delaware. They have seen the deed of incorporation. They say that they have been delivered the Article of Association, that under Article 23 of the Article of Association, an officer is authorized, that Mr. Whatever is an officer, and then you can conclude that you're authorized to act. So
agreed.
There are all sorts of tricks to do it. It's just stating facts, deliverables that you're receiving, okay?
Yep. But generally, though, I think for the Spanish lawyers here, you should just understand, the point is that for the most part, a notary in the United States can only attest to facts and facts, not opinions of law. And they're there mainly to say this person signing is who they say they are. I've confirmed, they've shown me their ID. They are who they say they are. That's generally the purpose of a notary, not to go through the contract itself like a notary in Spain does and actually authorize they call it autorizar a contract, and the proper translation of autorizar we can discuss for hours, but it's a very different role. I just want to stress that so hard that notary in the United States is a very perfunctory act compared to a Spanish. I think a notary in Spain is more like a super lawyer. They're not just a lawyer, but they've had additional training.
Very, very hard training. Very hard training. So that's true. So we have to, one of my recommendations since I was fairly young and back in New York, I experienced that, is you have to from day one explain to your, New York client what they should expect and what's going to happen. I found that Americans hate surprises. That's rule number one. They hate surprises. So I rather say from day one, listen, you will need each creditor to sign a power of attorney in order to. Otherwise, as alternative B, you can do this. It's not as safe, but I know and understand that it's very burdensome. May you want to consider, but from day one, they know what to expect. Okay, and then
That's such great advice.
It gets easier because
Yes.
you can't just don't do anything. Start marking up the credit agreement, giving comments, and then 5 days before signing or closing, say, by the way, here you have this form of power of attorney, notarize it, apostille, give it back in 5 days. It's not going to happen, and they're going to get crazy. They're going to be really
like, what have you done?
Yeah.
Yes.
Yeah.
It's very different stylistically. What about using all caps? What about this little fun thing that people like to do is put, names in all caps, or bold. Do you?
For companies, I think it's accepted. It's not malpractice. I mean, you can say El Corte Inglés S.A. And you could write El Corte Inglés in capital letters, and that would be
all through the contract, or just in that introductory?
Well, in the introduction, because then you would define El Corte Inglés as EFI or as whatever, or the company or the borrower or the lender or whatever. But you see that less and less at least in large firms. I think that's sort of relegated now.
I find it very jarring to see capital letters and all cap names in the body of the contract.
But you use them too.
Sorry.
I hate them, by the way. These jury provisions, which you always have in capital letters. Jury.
Oh, well, that's supposed to be there for emphasis. So,
okay.
or disclaimers. So you'll see the disclaimers in all caps. That's there for emphasis. Like, this is really important. But to put a name in all caps throughout the body, I find a bit jarring and unnecessary. It's kind of like, and you see this still in many Spanish contracts. When they're introducing the parties, they'll say de una parte, de otra parte, and I think 50, 60, 70 years ago, we used to say party of the first part, party of the second part. That's the equivalent, but nobody does that anymore.
No, less and less in Spain. If there are two parties, you might find that it's often, de una parte, de otra parte. If there are more than two parties, I would say parties. Roman 1, Roman 2, Roman 3, Roman 4, and that's it. I mean, that's what we would do here, at least, and in most firms, I think.
All right. Well, we've discussed that introductory clause ad infinitum at this point. I think that's enough. What comes next, Charlie? What comes next in these contracts typically?
Yeah, you can divide. You go from the introductory clause to the recitals, and please, as I look for it, I'll try and bring it up on screen. Why don't you tell me what's different about recitals?
So recitals are the next part of the contract where the party, sometimes you see the heading witnesseth or witnesseth that in all caps. In Spanish, they often say exponen. It's not really needed. It doesn't really, to give it a title is not necessary, especially if you're using a whereas introduction. Whereas the seller owns beneficially and of record formerly in shares of common stock, as you see in the example on the screen, you don't need recitals there to introduce it. You probably do want to say recitals if you're doing a more simplistic, straightforward description of the recitations. And you can go back and forth on whether or not recitations are really needed in a contract, whether judges really pay attention to them or not in the event of a dispute. But these are the two different styles of recitals that you will see in an American U.S. drafted contracts. And I don't know, Carlos, what do you think?
I think it's quite different in Spain. I would recommend using recitals as much as you can, because I think they give you context if they're properly prepared, especially in a very long contract, what you're going to read about You know, who are the shareholders? What is the timing? The conditions of the transaction? The how it started with maybe with a memorandum of understanding, sort of. So you have sort of a history of the deal or the parties, whatever is relevant in the context. And so you start reading the contract knowing what the hell you're reading. Because what I find very annoying, frankly, is getting a 200-page LMA contract which says financing agreement. And until page 80, I will not find out what exactly is being financed, who is being financed, what sort of facility is being provided. Because first I will find 60 pages of definitions, which are not going to help, and then lots of clauses that inevitably go back to the defined terms. So you really have to struggle to find out what exactly, to have a picture of the whole deal. So I do find very useful, and I think that the Spanish courts would appreciate having recitals, proper recitals. Okay, now whether they have legal value or not, they do not create obligations, they're just recitals, but they describe a situation and they give context, and they can be used for interpretation, of course, if there's any doubt.
I'm a big fan for two reasons. One, whereas is kind of funny to me. It's quite archaic language, but it was also really useful because I would draft mostly litigation documents. And so I would build my case off the facts. And then I knew the judge would read from my facts and I would go, and this is why we should win. And so I was always a big fan. And I want to put that in there because, Steve, I think you disagree.
As to using
Where,
whereas,
yeah, in their
it's
cycles.
just a bit archaic. I don't think you can state the same fact without the use of whereas. It's basically assumed that you are stating this fact because you're making a point, and the whereas doesn't add a lot to it. Narrative prose is fine, and simply state the facts. You don't need to say whereas. In fact, if you look at the clause on the screen, how much does the word whereas actually add to your understanding of the situation? Very little, I would say. It's simply a holdover from more formal, archaic times. I much prefer the recitals below, the example below, because, as I said, it's simpler, it's more straightforward. As Carlos said, you want to distill and not add unnecessary text. That's the only reason. It's not malpractice, as Carlos said, to use whereas. It's a preference.
Yeah, I guess I should, for full disclosure, I have an English literature degree, so I'm biased.
Yes. What about the lead-in? We call this the lead-in. So after the recitals, you'll have a lead-in, and traditionally, because of American lawyers' obsession with showing that there's consideration for the contract, consideration has traditionally been necessary for a contract to be enforceable. We're not going to get into the details of consideration. People have very long classes about that, but they would start off with a lead-in to the contract saying, now, therefore, in consideration of the premises and the mutual covenants set forth herein, and for other good and valuable consideration, the receipt and sufficiency of which are hereby acknowledged, the parties hereto covenant and agree as follows. Sorry, we don't have that on the screen there, but
Yeah.
I was looking for it. I'll take this down until we need it again.
But it's intended that there's consideration as the basis for the contract, and a recital can't transform a contract with no consideration into an enforceable contract. I think we've evolved over the years, and most courts aren't so concerned about whether or not there's consideration. It's
Here it doesn't add anything.
Assumed. In Europe, that's generally not an issue at all.
It's not an issue at all. I mean, it may be a contract or a different type of contract, but it will be a contract. In the worst case scenario, it will be a donation if you want. But
and so my suggestion is just the lead-in should be the parties agree as follows. That's good enough. That's all you need.
You don't need anything else here either.
So I guess now we're into the body of the contract, and I'm not sure. I don't think we have any screenshots for this, but we should discuss the kind of contract language that's used. And if you read books on contract drafting, like Ken Adams, they categorize the different types of contract language. There's like language of agreement, of performance, of obligation, of discretion, of prohibition, policy, declaration. There's lots. So maybe we'll just go. I thought it'd be a good idea. I hope it's not too boring. To go through the types of language that is used, and we can get into a little bit of nitty gritty for lawyers that need to draft in English. So the first one that Ken Adams talks about is language of agreement, and it's pretty simple. The parties agree as follows. So it's language where the parties are agreeing that such and such is a thing, exists. There's I don't think there's a lot of difficulty in drafting these clauses. Um, do you disagree, gentlemen? Do you have any points about language of agreement? What
Uh,
about a? Oh, go ahead.
no, no, I'm getting ready to debate about shall versus will, but I'm jumping the gun.
Yeah, we're not there yet. What about performance? Or let's just say, somebody drafts a clause and they say Repsol does hereby purchase the assets. That's language of performance. So they're doing something. They're not agreeing to something. They're agree to do something. Does
Well,
that
they're
sound right to
actually,
you? Repsol
the-
does hereby purchase the assets.
yeah,
Um,
if you are at the notary's office, say hereby purchase the shares. So you deliver the share certificate and you receive the price. It's in fact hereby acquiring the share. So you can perfectly well. What happens nowadays is that normally the contracts are subject to CPs, conditions present. So it's even if the condition present is met just 2 hours after signing the contract, or even at the same time, it will be subject to, I don't know, making this notice, receiving this authorization or waiver from the banks or whatever. So it will be drafted another way. Subject to the terms and conditions stated herein, the parties agree that Repsol shall buy and whatever shall sell. So it's more time, more often you will see this construction rather than hereby acquires or sells. But whenever I can avoid CPs, I avoid them.
It's a good point, though. What you're describing is language of obligation, not performance. So the language of obligation will I wanted to discuss. Language of performance is yes, X does Y. That's language of performance. So in this contract, under this contract, I now purchase the shares, for example. The only question is how wordy do you get? I do hereby purchase the shares. I hereby purchase the shares, or I purchase the shares.
I
Those
hereby
are your.
purchase. I would say we hereby Repsol hereby purchase the shares. That's the way I would normally draft it. Now, if that's translated to Spanish, it will be different. There's no hereby. It's the most
Bueno, por
similar
medio
would
del
be
presente
por el
is
presente o en este acto, por el presente o en este acto. That's what you would normally say in Spanish.
The next type of language is language of obligation, and here we get into some interesting points. This is typically you'll see the company shall reimburse the consultant for all authorized expenses. There's a big debate about using shall versus will, and it's funny because some law firms' English style guides specifically recommend not using the word shall.
Why is
And they've
that?
taken this because they've copied from comments from the legal English experts in the United States. So some of them argue that shall is not appropriate and will should be used, the future tense, will. Uh, the problem is they're not talking about specifically contract language. So they've
Oh,
taken recommendations, for example, for legislative drafting, and applied it to contract drafting. And we've been in a very difficult position trying to explain in the contract why we've used shall and not will, despite the fact that their English style guide tells them to use will.
I see.
And I don't think many lawyers in Spain are aware of this difference. And I think it's
No,
very
no.
important. You know,
No,
if
because if
you,
you translate to Spanish, I mean, it's not obvious. So it's venderá means it shall sell or it will sell in the future. It exactly the same word. So you have to see the context to either to determine if you're talking about something that's going to happen in the future or something that must happen because it's mandatory for it to happen. So the context is going to give you that. But what you're saying is right.
My argument is that will expresses a future time, but it
Yes.
doesn't specifically express an obligation. Shall means you have an obligation. Shall
Right.
is really equivalent to must.
Yeah.
They mean the same thing. Must is a bit strong to use in a
Yeah.
contract.
Yeah.
Sometimes you use it for emphasis, but generally, if the verb you're thinking about in Spanish is venderá or ejecutará or whatever, future tense, you really want to use shall because it marks future time like will, but it has that mandatory aspect that you shall do this.
Yeah. In Spanish, you could translate like deberá ejecutar, but
But
sorry.
that would be must. That would be, in our sense, that would be you
Yeah.
must do this.
Yeah.
From
So
a Sorry to cut you off. From a speaking versus writing perspective, shall is very much in contract writing and not actually in speaking. Because if you
correct.
if you start saying like Uria Menendez,
You shall not pass, as
yeah,
the wizard
You
said.
You shall.
But I have to totally agree with shall in a contract for obligation. Must is much more actually spoken English and less formal. Shall is payment shall be made by January 2nd, 2000, whatever. And so I feel strongly about it, and I'm surprised style guides actually go against it.
Yeah, I think it's a real error. I think nobody pays attention to these style guides, anyways, unfortunately. But when we're translating a document and it comes up and the client says no, use will, and then I have to explain why we shouldn't be using will, then that means somebody who drafted their English language guide needs to be taken to the woodshed, as we say, taken out to the woodshed, uh, which I'm sure you have a similar expression in Spanish, but back in the old days, if you got out of line and did something wrong, you would be taken to the back where the shed for the wood and
Yeah.
beaten.
Yeah. Here we would say al cuarto de las ratas.
Al cuarto de las ratas. See, I learned something new all the time. So what about language of discretion? So this is another idea. So we talked about language of obligation, the shall. We've talked about language of performance, which is I purchase or I hereby purchase. Discretion, what does that mean? So you have a clause where you're letting a party choose to do one thing or another. Typically, you would say standard co may exercise the option at any
Right.
time prior to January 1, 2026. Do you have particular drafting
Well,
suggestion?
the equivalent of may podrá, or if you want to stress it further, you would say tendrá la opción de elegir o podrá decidir si, or you can use expressions to avoid any sort of ambiguity. Normally if you say podrá, it means podrá. It shouldn't be discussed, but yeah, I don't think
I see a lot of X may from time to time exercise the option, or may at any time, or may at his discretion. Is any of that necessary?
Well, in a contract, I would try to make clear if there's either a deadline, long stop date to exercise an option, or if it's indefinite, I would stress that it should be that party is entitled to do it at any time during the term of the contract. I would stress it so there's no doubt that that's something that can be exercised at any time and not in particular periods of time, or not at the beginning of the contract, or because maybe contracts are complex and someone can build the argument that this was really confined to this phase of the contract, but not that phase of the contract. So I tend to be as precise as possible.
Interesting. All right. So there's an argument for a little more than just the bare minimum, which is what I usually argue for. And reasonable people can disagree. I think that's fine.
I think you'd agree. You want to use may and not might when choosing your modal auxiliary verbs. I don't think I've ever seen a contract with that, and the party might.
You would see it in Spanish contracts because they're not properly drafted. You see it sometimes. Sometimes, not, but you do see them. I'm sure Steve came across that several times.
We've come across lots of interesting,
lots of things,
examples. Never from Uria Menendez, though. Never.
Oh no, of course, no.
They're all perfectly drafted. What about language of prohibition? So we went back to my example of "you shall not pass," as Gandalf said in the movie. What language would you use? So for example, you could say Standard Co. shall not sell the shares to Holdco, for example.
Simple. No venderá. That's as simple as that. No venderá. Or no podrá vender, or no venderá, whatever you want.
How necessary do you think in English, assuming it's not a translation, to say must rather than shall? Standard Co. must not sell the shares. Does that add anything to the trend? I don't think so.
I would say shall not. I mean, I don't know. You know better than I do, but I would say Standard Co. shall not sell the shares, right?
Yes, I think must is a little too much. It's not.
And then you have variations from that. I don't know. Is restricted from selling the shares. Is prohibited from selling the shares. So I don't know. You could find in a loan agreement all sort of expressions like this. Negative covenants, prohibitions, restrictions, and all that. So there are different ways to phrase it, but the simple mode is shall not. Huh?
Absolutely, I agree. What about language of policy? So Ken Adams describes language as policy as rules that the parties have to observe. For example, any attempted transfer of the shares in violation of this agreement shall be void, will be void. Which would be the better drafting of that clause with language of policy here? This is a policy between the parties. One party definitely can't sell the shares in violation of this agreement. Is it shall? So you're talking about a future act. Any attempted transfer of the shares in violation of the agreement shall be void. Is that right?
Doesn't sound right to me. I would use the future tense for the future. Yeah, I think you were giving me a leading question, though.
Yeah, it's a leading. I mean, this is what Ken Adams recommends in his manual. He's one of many people that have written on contract drafting. But I think I agree here. It's not shall, although the temptation is to use shall. This is really, this will happen if you do X, and so it will be void, not shall be, because that's language of performance. Using shall. And here, this is not language of performance. This is language of policy. This is the policy. And if you breach this policy, this will happen.
Yeah. Would it help if, to avoid any doubt, to say that the parties agree that if this happens, the contract will be void? So it's the parties that are, it's very clear that the parties are stating that that's the effect that in the future they want. I don't know. Well, I'm probably translating from Spanish. I don't know.
Well, you could redraft it as language of performance by saying the parties shall not transfer shares in violation of this agreement. That's language of performance, and it has the same effect. But it's more language of performance. The parties shall not, as opposed to if you violate this agreement, for example, then X will happen. It's simply the use of the verb and the proper use of the verb, and not inserting shall, even though we prefer shall, not inserting shall where it doesn't apply. And that's why, for example, when we had this issue of shall versus will in this translation of this document, we couldn't go through and simply do search and replace all instances of will with shall, because in some cases, will is appropriate when it's not language of performance, when it's a language of policy, for example.
Mhm.
So I hope this isn't too complex for our listeners. I
No, they
really
teach this in baccalaureate in Spain, so I certainly hope that modal verbs on intention. No, I think we're good.
okay. Let's do one more. This is the last one, which is language of declaration. And
Yeah.
this deals with representations
Right.
and acknowledgments. And so
Right.
the
Right.
representation, these are very important for
Yeah.
lawyers on these large, sophisticated transactions. The
Right.
reps and warranties, the acknowledgments. So a typical representation is standard co represents that it's in compliance with all applicable
Yeah.
laws.
Or at least a long list of representations, actually, that's what you normally see now. You
Yes.
wouldn't see that in a contract in the 80s. You started seeing that in the 90s, I think, in Spain, I mean. And we do use representations virtually in every contract nowadays. And I think they are helpful sometimes, but sometimes I think they get a bit absurd.
You mentioned about in good standing, how that means nothing in Spain.
But that's just that's incorrect. Simply, that's just incorrect. You can't say a Spanish company is in good standing. You can say it's duly incorporated, but other than that, I think some representations just don't add anything. I'm not saying that we should not make them or request them, because there are standards you follow, and you know how this works, and that's what the clients expect to see and all that. But frankly, if I represent to you that I'm duly empowered to sign the contract and I am not, and I'm a Spanish party, there's nothing you can do. I mean, you have no contract, actually. Maybe you have a tort claim or something, but it's not going to add anything. If I represent that I'm a duly incorporated company and I'm not, you're dealing with no one, really, okay? Or if, I don't know, I could give you several examples like this one, that the contract is valid, binding, and enforceable, and it's not, then you don't have anything to claim. So I'm not saying.
Yeah, it's funny. It's very jarring.
I can see situations where this adds value, because, for instance, in a loan agreement with several disbursements, a typical credit agreement, the banks can stop disbursements if a rep is false or inaccurate. So that adds value. They say, no, we found out you don't represent the company, or that it's not valid security, or that whatever, you're not duly incorporated, so we're not disbursing any more loans. But other than in that sort of situations, it's really not adding any extra protection to you. And you do it critically. People don't really stop a second and say, what I'm writing here is not, that doesn't make much sense, really.
And we get back to that example I gave on the Inter-American Affairs Committee, is that the problem is that the American lawyer is going to say, I've never seen a contract without these reps.
And that's the end. And that's the end of the discussion. So I don't even try it. To be clear, I don't even try it. I'm just saying that from the first day I saw a rep, I sort of scratched my head and said, so if this is not true, what's the consequence? I don't get it, really. But I already, there's nothing you can do, really. That's. But
it's a good idea for the Spanish lawyers, young lawyers, to read a bunch of these reps and warranty sections, and just get familiar with at least understand the concepts, what they're trying to convey and why. And then you can advise them that certain representations and warranties really aren't necessary if this is going to be enforced in Spain, for example.
Yeah, between Spanish parties, maybe not financial institutions, which tend to have these protocols of how doing things. You don't need to say that I represent that I'm duly empowered to. You actually deliver your powers of attorney, and the lawyer of the other side will check the powers of attorney and will get comfortable that in fact this person can sign on behalf of the other party. So you don't need to represent. Actually, if this contract is going to be signed in front of a notary in Spain, it's the duty of the notary to check that the parties are duly empowered to sign the deed in front of the notary. So again, a representation will not add anything. And you can do that with, between Spanish parties or with several type of counterpart. But with, let's say, in the financial arena, it's not going to work. You will have to sort of tick the box of every of your checklist.
Excellent. Well, I think we've pretty much covered the body of the contract. Um, what do you think, Charlie, about breaking up the contract into articles, sections, subsections? You know, when you draft, do you put Article 1, the parties, Article 2? Do you do that typically?
I'm a big fan of headings and of making it as obvious for the judge to find where and why we should win. So I was big into cutting things up, but I was mostly doing litigation in wills and estates. So when it comes to corporate, etc., that was my approach for that reason.
Carlos, I mean, what do you think? Articles, are they necessary for every contract?
When you mean articles, you mean stating
Article
section.
1, broken down into
I
sections.
would say, yeah. We have a numbering of the contract and sort of ideas grouped by in paragraphs, subclasses, subparagraphs. Yes, I think it adds order and it makes easier to find what you're interested in finding. And
I think for large contracts, you group sections into articles, and so you'll have an article for each major topic that's broken down into subtopics.
Right.
But only if there's more than 25 sections. I mean, only if there's if it's a short contract, you don't break it up into articles and sections.
In Spain, we would, I think, we would in any event,
Oh, yeah?
Even in a short contract. Yeah, I would say clause 1, clause 2, clause 3, clause 4. And even if it's 3 pages, it will have.
Yes, clauses, but not. So when I say clause, I guess cláusula uno, but artículo uno, cláusula uno, subcláusula or.
Okay. All right. I see. All right. Yeah. You will keep it simple. Yes.
Yeah.
So we'll keep it simple.
Right. Did you want me to bring this up, Steve?
The subsections?
Yeah.
Yeah, sure.
Okay. Part of me thinks, though, if you can't stand in front of a court and say, subsection 205 A3 states, that to me was a big part of legal training. But is that what you meant? Because I was thinking when it came to headings, it was, I guess, bigger as opposed to saying each line.
So here, if you look at this example, how would you, if you needed to talk to another person about that last paragraph, okay? Certificates representing all the shares duly executed in blank or accompanied by stock powers duly executed in blank. If you said, hey guys, we need to redraft section 205A2, AII, how would you refer to that paragraph? And I'm saying this because there's a little quirk that I learned as a young associate. That people sometimes refer to, at least 30 years ago.
I put the Roman numeral 2. I would say 2.
I
reference to, you would say section 2.05A, 2 in the hole. 2 in the hole.
We would say little Roman 2. Romanillo 2.
Well, in the project finance department where I work, they would say 2 in the hole, which I thought was cute. All right, so we've discussed, some of these formatting issues. What about the back of the contract? What about the concluding clause? So you had your introductory clause, and then you have I think it's back up. Yes, go down one.
Is it this one?
Yes. Or maybe we didn't include it. It may not have included.
Yeah, it does. I don't see it.
Clause is simply a paragraph that says, in witness whereof the parties to this agreement have caused this agreement to be duly executed as of the day and year first written above, or first above written. Very typical in U.S. Anglo-Saxon contracts. I assume there's something similar in Spanish. In fact, I'm pretty
Similar,
sure there
simpler,
is.
I think, but we do add normally in how many copies it's executed, because you have the counterparts section in your boilerplate language that says this contract may be executed in any number of counterparts or something like that. You used to say,
Yes.
right? We will
Yes,
normally
that's it.
say this contract is signed in 5 counterparts: one for the seller, one for the buyer, one for the guarantor, and whatever.
That's
It's just tradition. I mean, it's not really
Well, it's
important.
also because people are no longer in the same room signing the documents all together. Back in the 90s, you'd have a big closing and you'd have all the parties sitting in the room and they'd be passing around 15 copies of the contract and everybody would be signing every single signature page.
Right,
That
right.
doesn't happen now. So
No,
you need
no.
you need to have the separate signature pages sent in, and that's the
Yeah.
reason for it. You were just
Yeah,
talking.
that's something that shocked me also when I started working in New York. It was this signing by counterparts. I was saying, "What's that? What do you mean?" No, I'll send you the blank pages. Ask your client to sign for what? No, I
Yeah.
mean, I want to see the whole contract. Until I realized, I was doing something really stupid. I was going completely against the. So now,
Yeah,
yeah,
nobody
now,
wants to have to spend time
no,
going
you
to.
sign by counterparts, and if it's a reputable firm, it's held in escrow, and that's it. I mean, we do that too, so it's not a deal, not a big deal now.
So I thought it'd be a good idea just to show the audience this is what a typical signature page looks like. It'll either have the actual signature or it will have this /s/
Mm,
signifying that it's been signed without the
mm,
actual signature.
mm.
And I don't know if you have any comments there regarding this format.
Ours is very similar. We'll just say por poder, PP, por poder, which means that you don't need, if you have already spelled out in the first page why this person is authorized to represent David Huey, you don't need to repeat this person is a sole director or has a special power of attorney. If you haven't, then maybe it's the good place to say special power of attorney dated whatever. I mean,
Right. Although for translation purposes, when they put por poder, you'll often see it translated in various strange ways by power.
I would say by. I would say
Just
by.
by is
I
good
would say,
enough.
I would
Exactly.
say by.
And then, yeah, there's no, we used to have the concept of being sealed, whereas contracts were sealed, and you'd see the word sealed, or you'd see an actual seal on the document, or LS, but it's not required for the most part anymore. You don't see it in contracts unless there are certain instances where for purposes of the statute of limitations, el periodo de prescripción, as you say
Yeah,
in Spanish,
yeah.
you extend the statute of limitations if the document has been sealed. But those are rare cases that I don't think you have to worry about too much.
No, we haven't seen that. I don't remember seeing that.
And then finally, attachments. So there's a big debate always about how do you translate anexo. So attachment is generally anexo, but your word anexo, we have various different words to describe the types of attachments. They can be called attachment, but you can have schedules, you can have exhibits, you can
Yeah.
have annexes.
Mhm.
There's all these different words that we use. I don't know if you have any thoughts on this, Carlos.
I would personally follow the system you have there on the screen. I would call schedules what we call annexos. And if I'm writing in English and I'm attaching forms of agreements, of certificates, or whatever, I will say I will include them as exhibits. Or simply as schedules, everything as schedules. I mean, that's when it's very long and complex contract. Maybe I will use schedules and exhibits, but mostly I will just use schedules.
And then finally, I think, the one other thing I wanted to talk about was this whole issue of definitions, defined
Yeah,
terms.
that's a good
And,
one.
are they included as a separate, schedule or exhibit? I'm not even sure right now. I've seen them
Sometimes a
both.
schedule, sometimes in clause 1 of the contract,
Yeah.
you'll find
Or clause one, exactly. The
clause
body of
1
the contract.
definitions and rules of interpretation is a typical way of dealing with it.
Yeah, the problem is sometimes the definition section can be 50 pages.
Right,
And
or even more.
do you want that in the body of the contract? I would say absolutely not. You don't want that in the body of your contract.
Tell the LMA, see if they listen to you. Okay.
But it makes
Yeah,
it
I
so
agree.
difficult to read and get to the guts of the agreement.
I think it's not very elegant, I have to say. And it's, again, you have to go to page 86 to see what the contract is all about, if you're lucky to understand. So I agree with you. If you can deal with that in a scale, it's better. It depends on the situation. I think the issue is not so much whether it's in clause 1 or in scale. It's whether we use defined terms. I mean, I'm just a bit critical with the way in some, in Anglo-Saxon practice, some defined terms, I just find them a bit unnecessary, let's say. If you want, you don't need to define Spain, at least for a Spanish contract. Spain is Spain. You can define Spain as the Kingdom of Spain, great, but it's not necessary. Or you don't need to define euro, or you don't need to define so many other things. I find that you could simplify those sections. The other thing, even more importantly, that I find in some contracts, I think they're poorly drafted in the sense that you go to a definition that takes you to a second definition. You still don't understand the first definition. You have to go to a third definition. And even I've counted up to 6 or 7 in a leverage loan. 6 or 7 definitions until I understand the first definition. It's a real nightmare. And I think that should be clearly avoided. When I talk about the rule of the Plaza de Castilla, this is the sort of thing you want to avoid. The court is not, or it's probably not going to do exactly what I described. It's going to say, what is this? This is incomprehensible. Okay, so you have to be a bit careful if this is the type of contract that's going to land in the table of the Spanish court. I mean, you should be able to read it, not to go to 6 definitions to understand the first definition. That would be my piece of advice here.
Great. Now, while we still have time, Carlos, I wanted to ask you, I think a lot of people will be listening to this and think, how did you get your level of English so high? You had been in New York. Was immersion a big deal? Did you study a lot of English? For the listeners of Mastering Legal English, what worked for you to get such a high level of English?
Well, I think it's by practicing it even 25 years after returning from New York, I think easily more than half of my work is in English. So this is my working language, like Spanish. It really makes no difference, and it's not the same. I mean, I don't speak English and write English as well as I do Spanish. That's for sure. But I'm comfortable. I'm not concerned if I have a meeting with an English lawyer or a New York lawyer. They used to be in an advantage, or they're maybe still in an advantage, but not as big as it used to be. So it's just by practicing. It's hours. That's all. Like many other things, it's like flying.
Okay.
I mean, I personally think that immersion is a great help. Either working in the jurisdiction, being in that environment where you have no choice but to interact in that language. There's no replacement for that. No matter how hard you try there are some really smart people that are able to do it without immersing themselves. But most of us, I'm not one of those really smart people, need that immersive environment where you have no choice but to communicate, and you make your errors and you learn, and people point out, hey, it's not pronounced this way, it's pronounced that way.
That's right. Or you send your form. I remember this. My form of share pledge. The first time I sent it to a very well-known New York law firm, and I got a markup from the associate that was reviewing it, and I said, it's pretty good. I mean, it really improves my template because, and we still now today use that markup as part of our template. And all this person was doing was really putting all the sort of bells and whistles that you would see in a US style pledge agreement. Some of them make sense, some of them not. You have to, go through the changes and decide what's right and what's not. But you're right. I think immersion is the key. If you have 24 hours to read a 300-page disclosure memorandum or offering memorandum, it gets to a point where you can read them pretty quickly. I will get an MA contract, and I can probably read it in an hour and a half, 2 hours. And you're talking about 200 pages, because there are certain things. I'm not talking about making a markup, but there are certain things that you know where they are, and the important things, you know how to locate them, and you know what defined terms you want to look for to see how things are dealt with in the contract. So it's just a technique. I mean, it's immersion, as you say.
And that's what the experience brings, obviously, is knowing what's important, what to focus on, and what really isn't a big deal. And so, absolutely.
Yeah.
But that's
Wonderful.
practice also. And as I always say, turn off. When you're watching a movie, turn off the dubbing. Maybe leave the captions on, but listen to your movies and watch your movies and television in English, in the original.
Right.
Turn off the dubbing. I know this is a big reason why the Spaniards traditionally had a hard time with foreign languages, is because all of the
Absolutely.
entertainment was dubbed into Spanish.
I think that's a huge mistake. It's a huge mistake, and that's the mistake you don't find in many countries in Northern Europe, where you get into a cab and the taxi driver speaks beautiful English, and that's because this guy has been watching American movies since he was a kid in English, and
Steve,
that's part of the reason.
Steve, you have a bit of an announcement with Juriscribe when it comes to legal English, don't you?
Oh, well, yes, we are now, officially a testing center for TOLES, the test of legal English. And, we're offering, we're about to, we haven't launched it yet on the website, so it's a little premature, but we are going to be offering testing as well as legal English classes to clients, in Spain and elsewhere. And so if you're interested, please let us know on kind of the larger scale, not the individual scale like Charlie's offering, but more classrooms. If a corporate entity wants to give its lawyers some improvement on their legal English, that's more of what we're focusing on.
Wonderful. Yeah, thank you. I hate to make it seem like I'm ending it early, but this is our fastest going, longest running episode. Yeah, absolutely. Carlos, I assume if someone's dying for a contract to be drafted, you're available. Is that right?
Not today. It's Friday afternoon.
Okay,
If I can avoid it.
Maybe on Monday.
Or maybe on Monday.
Okay. Well, thank you very much for being with us. I know at first it didn't seem like our most exciting subject, but somehow we made it exciting, at least to me. So thank you very much for being with us, Carlos and Steve.
My pleasure.
This is always exciting for me. I know I'm very boring, but these topics are exciting for me. So thank you, Carlos. It's been a real pleasure.
You're welcome. Very nice seeing you.
Okay.
Thank you.
Meeting you, Charlie. Thank you.
Thank you.